Hi, y'all, and welcome to tonight's live stream. Chad Daybell says that Lori Vallow Daybell manipulated him, and not just that she manipulated him, but that the state admits that she manipulated him. And he says that means he should get out of the death penalty. So, what is this all about? Is it going to work? And there's another question in there too, which is why is it that Chad Daybell might get the death penalty when Lori Vallow Daybell did not? What's going on there? We're going to talk about all of that tonight. So happy Monday. I hope you are all looking forward to the holidays. I have a request for you. Would you please give me your vote for some of the most interesting cases of the year? It doesn't have to be ones we've covered, it could be, but I'm looking for a large number of cases, several cases that you thought were super interesting from this past year. If you would do that, I would really appreciate that. Put that in the chat or the comments. And then separately, cases you're looking forward to for next year. What are some of the ones you've been following or thinking about or looking at in the news that you'd like to know more about? Things you think will hit next year, or at least there will be new information. So be sure to like the video and subscribe. We would love to have you join our group, our chat here on the channel. I also want to thank Atticus for a very generous super chat that rolled in right after I closed the live stream last time. So thank you, Atticus. Chad Daybell has a trial coming April 1st. As we know from covering it, Chad and Lori Daybell were both accused of murdering Lori's two children, JJ and Tylee, and of murdering Chad's wife, Tammy. They were tried separately. Lori's trial is already over. She was convicted, but she was not actually subject to the death penalty. It was just a straight up murder trial. Now, Chad Daybell's trial is coming April 1, and he is subject to the death penalty. The state is asking for the death penalty in his case. So what's the difference, and why was there a death penalty trial coming in one when Lori Vallow Daybell wasn't subject to that? What's the difference? So there were three motions that got lumped together by the defense in a recent hearing this past week. And I want to start with that so I can explain how this all came about. This is what Chad has to say. He said, as the state plainly put it at Lori's trial, he's talking about Lori manipulated Chad through emotional and sexual control. And Chad was not going to act without Lori saying so. Chad also argued in his brief, Mr. Daybell has lesser culpability than his co-defendant, Lori Vallow Daybell, who did not face the death penalty. Even when two co-defendants are equally culpable, it is unconstitutional and unacceptable to subject one of them to the most extreme punishment available, while the other did not face that possibility. Therefore, Mr. Daybell should not face more extreme punishment than the co-defendant that the state itself has alleged to be more culpable. So the argument that Chad is making is that in Lori Vallow Daybell's trial, and by the way, the state is going to disagree with this. I'm going to show you where they disagree with this. But they say that this is about Lori Vallow Daybell was in charge, and that the state represented over and over that Lori was the one who was the most culpable. It was Lori. And therefore, they have to make that same argument in Chad's case. They can't argue something different. They can't now come in and say Chad was in charge. And we're going to see all of that. I'm going to play you some clips from the argument that they had in court last week so you can hear it. It was a 3-hour hearing, but I've distilled it to 8 minutes. So it will be much quicker than that, and we can kind of go over all of what happened. So as I mentioned, those three motions got lumped together, and Chad Daybell's side wants to argue that the state has to be consistent. If it said Lori was the one who was in charge before, it has to say that now in Chad's trial. It can't say that Chad was in charge. And the reason that argument is so important, that was what's called a motion in limine. They were arguing that the way it has to be done the way it had to be done would prevent that the state should not be allowed to make that argument at trial, that it was a motion in limine to prevent them from presenting that evidence or making that argument at trial. But the reason it's so important is a couple of things. The first is that they also want to argue that Chad should not get the death penalty because Lori didn't. If she's more culpable, why should Chad get it? If she didn't get it and she was guiltier than Chad was. They also say it would be arbitrary and capricious to give to, even, let's say, Chad Daybell's side says they were equally. You can't, if they're equally guilty, you can't say one gets the death penalty and the other doesn't. There's something fundamentally unfair about that. And especially because it relates to his waiving a right to a speedy trial. So let's first talk about, okay, how did this come about? Because initially, the state asked for the death penalty with Lori Vallow Daybell. They wanted that with Lori Vallow Daybell, but it got stricken by the court. And I'm going to play you a clip from the Lori Vallow Daybell hearing back in March of this year, where the court struck the death penalty for Lori Vallow Daybell shortly before her trial started, just weeks before her trial started. So I'm going to play that little clip for you. It's audio only. There was no video available of this particular hearing.
Haven't found here any misconduct of the state.
This is the judge.
However, procedurally, disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally, even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit of the mitigation person who has said unequivocally they simply cannot have time to prepare and go through for mitigation the late disclosed discovery. Thus, considering everything, the court is required to fashion a remedy that honors the rights of the parties, the fundamental right to a fair trial, and the right of the state to bring to trial those who are accused of a crime.
So what has happened, and the reason Lori Vallow Daybell was even discussing this with the judge, is that the state had not produced items in discovery. They have been late. There have been delays. The court is very clear that he didn't find misconduct by the state, but deadlines were missed. There were, in fact, delays. And so the court said, at that point, I've got to look at whether this could prejudice the defendant, Lori Vallow Daybell. And in fact, it looks like we've got an affidavit from somebody helping her, and they're saying they really cannot go through and prepare for this. They can't look at whether or not this would mitigate, make things better for her, keep it from being as bad. They can't even look at it. There's not a sufficient amount of time because the state was so late in producing all of this. And therefore, the court says, here's what I'm going to do.
In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken. To be clear, the court does not impose this sanction to penalize the state, but rather to ensure the constitutional right of the defendant is protected, allowing for a reasonable defense to be prepared for this trial.
What you've just heard is what the court decided to do is to strike the death penalty for Lori Vallow Daybell, not because the state didn't have the right to ask for it, not because there was some reason that they weren't entitled to ask for it, but simply because it wouldn't be fair to Lori Vallow Daybell. She had no way to prepare herself given how little time the state had left for her. So therefore, the court said, I'm going to strike this. I'm going to strike it. There's not enough time. But think about the other side of that. The flip side of that is, if there is enough time to prepare, then there's no need to strike the death penalty.
The court determines that if I were to fail to address this discovery issue, I believe this case would inevitably be reversed on appeal if there was a capital conviction. With the defense assertion of prejudice, the court must determine what is an appropriate remedy. Here, because the court has found or has not found any willful conduct on the part of the state, the court is not primarily concerned with any sort of sanction or punishment. What the court must address is an appropriate remedy to try to mitigate the prejudice that has been caused by the late disclosures. Ordinarily, a logical remedy would exist here, and that would be a continuance of this trial. This has been proposed by the state as one solution, and the state has proposed to mirror a continuance in the companion case of the Chad Guy Daybell's case, the 1623 case. However, here, that's an option that I can't consider, because in this case, the defendant has unequivocally asserted her right to a speedy trial. In determining whether speedy trial is violated, one of the major factors is the reason for the delay. The reason for the delay here rests on the state and can't be counted against the defendant to justify a delay of her trial in this case. If I were to delay this case based on an issue caused by the state, I believe that would violate her fundamental and constitutional right to a speedy trial.
And right there lies the difference between Chad's trial and Lori's trial. Lori had refused to waive her right to a speedy trial. So she was moving forward to trial no matter what. For that reason, if things were produced late and she couldn't prepare for them, then it was on the state. That was the state's problem. Chad, on the other hand, had waived his right to a speedy trial, so he would have plenty of time to prepare. As a result, there was no problem with the state being late. They could just put the trial out. And they did put the trial out. That's why his trial is occurring about a year after Lori Vallow Daybell's. He has more time to prepare. Now, traditionally, it comes with consequences if you refuse to waive your right to a speedy trial, which is, you're in a hurry. You're the one who needs the discovery. Usually you want to know what the state knows. And so there's a consequence of that, which is you have to get ready really fast for trial. But the state usually has had a fair amount of time to prepare, because they don't have to file right away necessarily, depending on statutes and so forth. But they therefore have all their ducks in a row when they come, at least in theory, when they file. And so you, on the other hand, as a defendant, would need more time to prepare. So, and there's also sort of a playing along. It's generally speaking, it's kind of nicer for everybody if there's not a rush. And so it's nicer really for the state, for the judge, for everyone, if there's not a rush. But so Chad has done two things here. He has agreed to waive his right to a speedy trial, which would normally be a kind of playing along, getting along thing, but he's suffering a surprise consequence here. The surprise is that Lori Vallow Daybell got out of the death penalty for refusing to waive her rights. He waived his rights. Now he could be subject to the death penalty. So the argument, so that's the setting in which we have this hearing last week. That's how it all worked. And so now we're going to watch what happened at the hearing last week and some of the arguments on both sides.
Were combined. Mr. Wood would not have been able to say this was all on.
For just like the first little clip, I had it on 1.25 speed, so I'm sorry, it's a little fast. Then it slows down.
Lori, and she was the one driving the ship. She was the one directing this so-called conspiracy. She was the one in charge. And then turn around when it was time to talk about Chad and say the same thing. That would have been terribly inconsistent, and the jury would have said, which one is the truth? Which is the truth? Which is the truth, Mr. Wood? Was it Lori driving the force of the ship, or was it Mr. Daybell driving the force of the ship? Mr. Wood specifically said this was Lori, and she was the one in charge of the conspiracy. Now, the case law, particularly the federal case law, and Pierce alludes to the fact that a prosecutor cannot, in one instance, sit there and tell one set of jurors, a year ago, or whatever, 8 months ago, say one thing to one set of jurors and stand up in front of them and say, Lori Vallow was the one running the whole show. Tell that set of jurors that, and then turn around in Chad Daybell's trial that's going to occur starting hopefully in Ada County in 4 months, and tell them, oh, well, I know I told the jurors in Lori Vallow's trial that Lori was in charge and she was the one driving force behind everything, and she was in charge. But you folks here at this new jury in Ada County in April and May, I'm going to tell you something different. I'm going to tell you now I've decided that now Chad is the one who was doing all of this. And it was all Chad leading the conspiracy. It was all Chad who was the leading force, and he was dictating everything. So what my motion in limine is saying is that Mr. Wood can allege any of the facts he wants against Chad Daybell. What Mr. Wood cannot do under the case law, at least the federal case law and under Pierce, is Mr. Wood cannot make the representation that Chad Daybell was the one behind and leading the conspiracy, was in charge of everything. Now,
so that's the first argument that that the defense makes. That's the first argument. And they're arguing it would be inconsistent to say Lori was in charge and now to tell this jury that Chad was in charge. Now, the state has a number of responses that we'll talk about to that in a minute. But really, ultimately, behind, in my opinion anyway, behind all of this is the quest about the death penalty, to keep Chad from getting the death penalty. And that's how this is all going to end up spinning. Now, they also would like the state not to be able to make those arguments. They would love for the state to have to come in and say, just, Lori was in charge, but Chad was also involved or something like that, but not to be able to say Chad was in charge, Chad was a leader, and that's what they're trying to ask for here.
Now, in addition, Judge, and I'll cover the other ones now, the culpability argument is this, and it's just a fundamental fairness.
When he says the other ones, he means the other motions that they filed, these two relating to the death penalty that sort of spin off this
due process argument. And it applies in this one as well. Lori Vallow, who had her death penalty pulled as a result of the prosecutor not providing discovery and was sanctioned. Now what they're doing is they're seeking the death penalty against Chad Daybell because he waived his right to a speedy trial and he was not the leader of this. And on top of that, we're seeking the death penalty against someone who is allegedly is a lesser co-conspirator and wasn't even the leader of the conspiracy. So that's where the death penalty arguments, Judge, and I will leave it at that.
So I want you to notice a couple of things here. The first is, I think that this is going to be a chronic problem on appeal. I think I mentioned on the channel in the past that death penalty litigation is just different and it lasts a very long time. It's much easier for the death penalty to get overturned than, say, just your average case. It receives so much scrutiny, and for good reason. It receives so much scrutiny because of the fact that it is so important. It's a consequence completely different in nature from even life in prison. It is lack of life in prison, if you will. It's completely different. And so there's a lot of scrutiny by the appellate courts on this. So this is an argument. When he says at the end, that's where the death penalty arguments are, Judge, and I will leave it at that. He's dropping his first of several hints that he doesn't really expect the judge is going to grant this for him, but that they are making these arguments and that these will be heard again on appeal. And that is a problem for the case. The fact that the two defendants have been treated differently, even though it makes sense and is logical legally, it's also hard to understand on just a practical, personal level.
Lori Vallow was the one running the whole show. Never said that.
This
She was the one in charge of the whole conspiracy.
This is the state's response. The state's like, we didn't say that. We never said Lori Vallow's the one running the whole show, and now you'll hear the rest of it.
Never said that. Chad would do nothing without Lori telling him to. Never said that. Not the leader of a conspiracy. Never said that. So the defendant's contention is that the state argued at Lori's trial that Lori was more guilty or in charge, and therefore the state cannot argue that Chad is equally guilty at his trial. and that by claiming Chad is equally guilty, we would be changing the core theory of our case.
So their number one argument, their first argument out of the gate is that we didn't say that anyway. We never said Lori, she was in charge, she was number one, she was the head, and Chad just, barely did anything at all. We never even said that. That's his number one first argument.
This is the state's contention. We are not changing the core theory of our case. The state's core theory will be the exact same core theory as argued at Lori's trial, that Chad and Lori Daybell, along with Alex Cox, by acting together, by way of conspiracy, planned, aided, and abetted together, and encouraged and caused the deaths of Tylee Ryan, J.J. Vallow, and Tammy Daybell. Those same individuals conspired to fraudulently steal Social Security funds, and that Chad Daybell committed insurance fraud when he claimed the life insurance benefits for his murdered wife. It's the same theory. The defendant's argument ignores the basic law of conspiracy. Conspiracy requires an agreement and one overt act by one of the parties to the agreement. Once that is established, all conspirators are equally guilty.
And that is a theme that the state is going to hit over and over again. And I will say, I do think it's fair to say that throughout the trial, they said over and over that Alex Cox, Lori Daybell, and Chad Daybell conspired together, that they worked together and talked about how it worked, talked about all the emails and text messages between them. I do think that it's fair to say they talked about that throughout the trial. Now, they also are saying, step back for a minute, Judge, and look at what conspiracy law is all about. Because conspiracy law says once everybody agrees, then you're all equally liable. So it doesn't make any sense, Judge, to say that they've all agreed, but Lori is more liable, more guilty than Chad. That doesn't really make sense. If it was a conspiracy, they're all guilty. They're all equally guilty under the law.
At Lori's trial, the state presented ample evidence of Chad Daybell's involvement in Tylee, JJ, and Tammy's murders. What was some of that evidence? Now, I know that defendant's just talking about closing argument, but he's opened this door to talk about the trial. It all comes in. So what was some of the...
At this stage, the state is going to go through some of the evidence against Chad. And I thought it was really useful because it's been a while since Lori Vallow Daybell's trial. So it kind of reminds us, what is the evidence against Chad? What is it that told us or told the jury that Lori was guilty and that then will apply to Chad in Chad's trial? The jury concluded Lori was guilty. What will the state say when it comes to Chad? And he's going to kind of list through, and I pieced it together somewhat to make it shorter, but he's going to go through what are the various pieces of evidence that are most damning about Chad.
Evidence, text messages dealing with light and dark ratings those were between Chad and Lori. Text messages entered into evidence between the defendant and Chad Daybell, meaning between Lori and Chad Daybell, about Tamara Daybell being dark. And Chad Daybell said, "I feel she will be gone soon," about an application to increase life insurance to the maximum amount allowed. Text messages clearly talking about the impending deaths of the victims. Text messages and other evidence of an affair that provided a motive for the murders. Evidence regarding financial gain that was another motive. Where did we find Tylee and JJ's remains? In Chad Daybell's backyard. And who told us where to find them? The evidence was that Chad Daybell told law enforcement where to find them in his infamous text to Tammy about killing a raccoon and burning limbs. That's not saying Lori's in charge. We said that in regards to Tammy. We said that in regards to Tylee in the closing argument. Acting together, they caused the death. We didn't say Lori was in charge and made Alex and Chad do this. Now, to be clear, we did talk about Lori manipulating Chad. We talked about Chad manipulating Lori. That doesn't make one of them more guilty or less guilty. They left out the evidence presented by the state of Mr. Daybell's so-called patriarchal blessing to Alex Cox, which was strong evidence of religious manipulation of Alex on this defendant's behalf. They left out the evidence presented at trial that Alex believed Chad said everything Chad said, and he'd do whatever Chad told him to do. The fact that this individual that this defendant married within weeks after his wife's death is what the evidence showed. The evidence showed had an affair with. The fact that she's a common thread is highly inculpatory for this defendant. It doesn't make him less guilty.
So let's talk through a little bit of that now that we've kind of been reminded by the state about that. Some of the pieces of evidence that we will see coming in Chad's trial are, for example, that Chad, specifically Chad, not Lori, but he would write Lori, and they had a system for rating people as light or dark. People who were dark were evil, sometimes became zombies, were possessed by evil spirits, and then there were people who were light and had reached higher and higher levels of light. And one of the things that was true of all of the people who died is that Chad and Lori had assigned them as dark. They had become dark before they died. And so that was one of the things that the state said showed that Lori and Chad intentionally were killing these particular people. Then there was the fact that there was the affair between Chad and Lori that was ongoing, and they showed text messages to show that it was ongoing while Chad was married to Tammy Daybell. Tammy Daybell, the state argued, was murdered so that Chad and Lori could be together forever, that they believed they were meant to be as a couple, that they were meant to lead in the final end times of the world, and therefore nothing should stand in the way of that. Not children who were inconvenient, not a wife who also was inconvenient and furthermore prevented his marriage to Lori, that those things could be cast aside, and they conveniently became dark prior to the time that they all died. And of course, the state says were murdered. So then there was also the argument that, and they're saying, we agree that Lori was manipulating Chad, that she was causing him to do things so he could be with her, but he was doing the same thing. He was manipulating her, and he specifically is the one coming up with the ratings. In fact, there was that discussion when they were doing a prayer session, or I don't know, prayer session is the wrong word, but when they were doing a session where they were casting out the evil spirits that were in some of the people who ultimately died. And there was testimony from some of the people present that it was all women, Lori and some other women. And Lori kept calling Chad saying, what about now? Is the evil spirit gone? Has it happened yet? And at no point did Chad ever say that it had happened. So there was definite involvement, according to the state, of Chad in all of this. There was also, and it was strange, but there was a text message from Chad to Tammy before she was murdered, before she died. And this text message said, and for Chad's purpose, may I say, it has not been proven yet that Tammy was murdered. That's something the state will have to prove. For Lori's trial, the jury concluded that Tammy Daybell had been murdered. But there was a text message from Chad saying that he had shot a raccoon and buried it in his backyard, that he buried it in the pet cemetery there. And the state says that was just a convenient way to explain the fact that what had really happened was Chad and probably Alex had buried JJ in the backyard in the pet cemetery. And there needed to be some explanation for why there was overturned earth and why it was so obvious that something had just been freshly buried. And that's why he wrote his wife a long, chatty text message, unlike he normally would do, saying, shot this raccoon, buried it in the backyard. Let's keep going.
No, all of the facts that he brought up about raccoons and all the other stuff.
Sorry, I need to give you all a little heads up post here. So we have now switched from the state. We are now back to the final arguments from the defendant, sort of closing this out, and then we'll go back and forth with the state and the judge one more time.
Do all that he wants. He can do everything he wants. Have at it. What he can't do is stand up in front of that jury and tell them that Chad Daybell in any way was the one who was the driving force. And that's exactly what he said to the Vallow folks. He told them that Lori was in charge.
So the defense is making the point that we're not arguing that this evidence can't come in. To the extent you have evidence that Chad did this, that, or the other, sent this text message, showed up here, had a phone call here, had an affair, that evidence can come in. But what you can't do is say he was in charge. You said that about Lori. You can't say that about Chad. That's what they're trying to argue.
One thing that I will indicate with regard to the defendant
The
is he has an
prosecution.
additional count of first-degree murder over and above what his co-defendant has. He also has 2 counts of insurance fraud over and above what his co-defendant had. Those are specifically in relation to the death and the homicide of his wife, Tammy Daybell.
Now, that is a really, really good argument right there. The state is saying even if the two of them, even if his arguments were right, that he wasn't, quote, in charge and that Lori was in charge of the other ones, that's not our allegation as to the death of Tammy Daybell or these 2 extra counts of insurance fraud. He's separate there. He's got an extra charge there that she didn't even have. And therefore, we definitely could, Judge, say he was in charge of those.
In this case, again, the state's theory is absolutely the defendant intended for 3 homicides to take place, not just one. Manipulated not only those around them, but each other. And that they did so with a common goal in mind, that goal of being together. To ultimately achieve that goal, it included the ending of 3 people's lives and had the underlying goals as well of financial gain and lust.
So the state is saying, look, we've already shown that, or we think we will show, we have shown with Lori, but we will show again that this wasn't just a coincidence. Chad Daybell intended for 3 homicides to take place. And when it comes to a conspiracy, that's all it takes. He had a full intention that 3 homicides happened. JJ, Tylee, that his wife be murdered. He wanted that. It was intentional. And they manipulated not just each other, but other people around them, like Alex Cox. And they did that in order to accomplish their goal of murdering 3 people. That was what they wanted. They had an underlying goal. And now we're going to hear again from the defense. Final argument. Sorry, I think I said that was their final argument before. Here's their final argument, and then we're going to have a quick note from the judge. So if you have questions, go ahead and be putting those in with question marks at the beginning so I'll spot them.
The relative culpability simply is that if Mr. Daybell truly was the second wheel or a lesser wheel in this thing, and Miss Daybell was driving the ship, he's being punished for the waiver of his speedy trial. And I'm just, for purposes of this motion, Judge, I'm just preserving this for future consideration if there is a conviction of any kind, and that can be addressed at another court, Judge.
And I'll just make it.
So when a lawyer says that, I'm just preserving this for future consideration. If there's a conviction, it can be addressed at another court. Basically, the lawyer is flashing, I don't think you're going to grant this. I don't think this is going to happen. You're going to tell me no. It's pretty clear that either you can't rule or you won't rule for me. I'm kind of surprised, frankly, that Chad's lawyers were telegraphing that. That's how I read it. I am not at all sure that they needed to do that. It does seem to be inconsistent. I think the judge has a good argument. Well, I'll say this for the end, but I wanted you to notice the way he said it.
A final note and comment. I'm going to take the matter under advisement, but the court would note that at the time I made that ruling on the Lori Vallow case, I also made an explicit finding that the ruling there in no way impacted or affected the ability of the state to still seek the death penalty as it related to this case with Mr. Daybell.
If the trials were combined.
So what the court says there, he says, I just want to remind everybody that when I ruled that the death penalty was off the table for Lori Vallow Daybell because of the fact that the state had failed to produce this information in a timely manner, this discovery, when that happened, I said at the time, I'm not ruling on Chad's case. I'm ruling on Lori's case. So he gave himself the room. I think he is going to have a good argument, legally speaking, that the 2 cases can be treated separately, that the 2 cases have a different basis. What happened in Lori's case did not happen in Chad's case. But the reason for that is that Chad did waive his right to a speedy trial and Lori didn't. And I think Chad is going to have an argument on appeal, perhaps significant. It will really depend on the appellate court, that there shouldn't be an arbitrary difference based on somebody giving up a right. It should be the opposite. If you give up a right, you don't lose two rights. But the death penalty off the table is not a right. So but I'm just saying this is going to go round and round. This is not going to end here. This is going to be a clear argument on appeal. I'm surprised he tossed it aside so quickly when he spoke to the court as, I'm preserving this. It's for future consideration, another court. I'm surprised because I think it will be a very hard fought argument when appeal time comes. It isn't something that just is going to get tossed aside. So I don't think the judge has to strike the death penalty. I don't think that the judge does. He set it up appropriately so he doesn't have to, and yet is going to create problems down the road. It's going to create issues on appeal. So I think that both of those are true. So let me take a look at some of the questions. I saw some question marks. I'll start at the bottom. Let's see. Jean wants to know, do you think Chad will take a plea to avoid the death penalty? It's possible. It depends on whether the state will offer it to him, and I don't know whether they will or won't. I don't know if it's been discussed or if there are negotiations, but it's definitely possible that he would do that to take it off the table, which is all the more reason why he'll throw out all his motions now to try to get the death penalty off the table now. If he can do that, he doesn't have to give up his trial. He could go ahead and go on to trial. So Mary Cat is asking me, the state didn't get info to the defense in time, but death penalty or not, didn't the trial still start at the same time? Didn't they have to just go through it all anyway? That's true for Lori. For Lori, the trial started just on time, even though they got the information late. And Lori said, it's so important to me that I maintain my right to a speedy trial that I'm going to go in somewhat unprepared. I am willing to do that because I demand my right to a speedy trial, even if it makes it difficult for me to respond to certain new things I wasn't told about in advance. And that's why the court said, okay, I've got to figure out how to balance this, because on the one hand, she has the right to go forward, but on the other hand, should she be penalized when she goes forward because they had this information they never gave her, and so she didn't get a chance to prepare all the way? That's not fair either. So that's when he came up with the solution of pulling the death penalty off the table. Chad, different story, right? Because he didn't waive his right to a speedy trial. He insisted on going forward. I'm sorry, he was willing to delay. It was Lori who insisted on going forward. He was willing to delay so he would have time to prepare. All right, let me keep going. Will Lori still be in Arizona for Chad's trial? Was this a coincidence? This is from NF Mom. In effort to make sure she would not be available for Chad's trial. I don't think so. I think that they waited until after the trial and they started making moves really quickly after that with requests for her to be sent to Arizona, requests for agreements between the governors that she could be moved from one state to the other. So I think that it was, I think it just was the timing. That's just when the timing was for her to be in Arizona. I don't think they would have called her in Chad's trial anyway. So I don't think that, I think she would probably, she didn't testify in her own trial, so I think she would just take the fifth if she were to be called. Let's see. Looking for more question marks. Let's see. Okay. Diana, who murdered Alex Cox? That is such a good question, Diana, and we do not know. And in fact, it's not even known that he was murdered. The finding was that he died of natural causes, not murdered. And yet there is, of course, speculation that he was actually murdered. Chastel asks a good question. Why were Lori and Chad's cases severed in the first place? And they were severed because of the difference that Lori was not willing to waive her right to a speedy trial. She wanted to push ahead and Chad didn't. For a long time, there was a push to keep them together. The state wanted to try them together. It'd be cheaper. It'd be get it all over with all at once, put all the evidence in, witnesses show up one time. This is being tried out of the county where it originally happened. So prosecutors are coming in, people are coming in, witnesses, and it's a lot of trouble. So get it all done at once was the theory. But it didn't, because they were doing different things. Lori refusing to waive her right to move forward to trial and Chad waiving his, the court had to sever them. It was not something that was actually desired. Okay, I think I have mostly answered the questions. So I want to say thank you so much to all of you who continually come back, watch the videos, hit the like button, subscribe. I'm so grateful to have you. I'm so glad you're along for the ride. We go live Monday, Wednesday, and Friday at 7 p.m. Eastern Time. I want to thank Marlon and Mama Pinks. We're glad to have Mama Pinks back with us tonight. I want to thank them for moderating, and I will see y'all in the next video.